great pleasure to welcome you to our discussion about what you need to know about the Connecticut Paid Family Medical Leave Law. My name is Lori Alexander. I'm a labor and employment lawyer with Littler Mendelson in New Haven, Connecticut, and I'm also the managing shareholder of the New Haven office. I know we have a big group today. I'm pleased to say that more than 800 people have signed up for this webinar. I know most of you have been withholding state paid family medical leave taxes since January 1st of this year. And now you're wondering exactly how the program is going to work come January 1st, 2022, when people are going to start being able to and eligible to take leave under the law. I know as you approach January 1st, I've heard from a lot of clients about setting up their own internal procedures to make sure you're ready for January 1st, and wondering about the timing of approvals from the Connecticut Leave Authority, how paperwork will actually be handled, what the paperwork looks like, coordination between your company and the Paid Leave Authority, and coordination between your other paid benefits and paid leave that's available under this new law. Well, we're pleased to have the experts with us here today to address your issues. Many of you have sent questions to me or sent questions when you registered for the webinar. I have passed those on to our presenters today, and I know that they'll be addressing many of the questions that you folks who are on the ground are asking, and you want to get clarification on prior to January 1st. So it is my pleasure to introduce our presenters today. Andrea Barton-Reeves, who is the Chief Executive Officer of the Connecticut Paid Family Medical Leave Insurance Authority, which we're going to refer to as the Connecticut Leave Authority, and Aaron Choquette, who is General Counsel of the same organization. They've been working with this, planning this program. They're the folks who are into the weeds on the details of how this is going to be implemented. And together, I know that they're going to give you a ton of useful information today, and we're very grateful for their participation. But before I turn it over to Andrea first, I wanted to give you a little bit of context. So if we could advance the slide, please. Most of you know that federal FMLA applies across all states, but federal FMLA is unpaid. And currently, as you know, there is no federal law that requires private employers to pay for family medical leave. So states have taken up the charge on this, and it's really a state-by-state analysis for those of you who are multi-state employers about whether employees within your organization are entitled to paid family medical leave. We all know that there's the Healthy Families Act that was introduced in 2019, and that would require paid sick leave, but not paid family medical leave. There's also the Federal Employee Paid Leave Act, which applies just to federal employers. And it also covers only paid parental leave at this point. If you could advance the slide. So by the end of 2020, only 9 states in the District of Columbia offered state-specific paid family leave. And it's not surprising that Connecticut is on the forefront of this. We do expect that there'll be a growing number of states that require the payment of paid family medical leave. Each of the states has slightly different rules and regulations. So we're going to be focusing only on Connecticut right now. And with that, let me turn it over to Andrea.
So thank you everyone for being here today. My name is Andrea Barton-Reeves, and let me just turn on my video for a moment, and I'll turn it off as we start the presentation. My name is Andrea Barton-Reeves, and I am the CEO of Connecticut's Paid Leave Authority, and we just simply call it the Paid Leave Authority. Let me get my slides, don't want to cooperate here. Here we go. I started this job in March of 2020, probably about 11 days or fewer before the pandemic hit last year. So we've been standing up the Paid Leave Authority remotely, and it remains an agency that is managed completely remotely. So all of our staff are working remotely and will continue to do so for the foreseeable future until we have an opportunity to return to offices. I came to the Paid Leave Authority from Park in Hartford, which is an agency that supported people with intellectual disabilities and its families. I am originally from New Jersey, where I hold a bachelor's degree in English from Rutgers, and I do have a law degree from the New York Law School. And joining me today is my very esteemed colleague, Erin O'Brien-Choquette. So Erin is our general counsel of the Paid Leave Authority. She has worked in the Department of Administrative Services for 14 years. And last October, she agreed to come to be general counsel at the Paid Leave Authority. She has served as a trusted advisor to 7 commissioners of the Department of Administrative Services, and she is essentially regarded throughout the state as the subject matter expert on all things family and medical leave. And that includes her being the co-author of the Family and Medical Leave Entitlements manual that is used throughout the state. And she also is a graduate of the College of the Holy Cross and Columbia Law School, where she was a Harlan Fistone Scholar. Okay. So let's start today talking about what is the paid leave program, what is FMLA versus paid leave, and how the paid leave program will be implemented, how it will be put into practice, what happened when workers apply for their benefits. We do have additional resources on our website that we can speak with you about, and then we'll have an opportunity for questions and answers. Generally, a Paid Leave Authority was created by statute in July of 2019, signed into law by Governor Lamont, and we have 5 primary purposes. They are outreach and engagement, which we're doing today, so we appreciate the opportunity to be here. We are responsible for developing all of the policies and procedures that are needed to run the program, the public program, and also those programs and paid leave benefits that are offered in the private sector pursuant to the statute. We establish the trust fund contribution rate, and we also receive those contributions to a trust fund that is held by the Office of the Treasurer. We audit and approve the private plans, which I just made reference to. And finally, we are responsible for administering the claims for the paid leave benefits, which will start in January of 2022. Here are some of the key dates that you should be aware of. We did start asking employers to register with the Paid Leave Authority in November and to deduct from employee wages the 0.5% that is deposited into the trust fund in January. For those employers that opted to provide their own family and medical leave paid leave program, we opened the application process for those private plans starting in January. And there are about 360 employers who are offering private plans to their employees. The quarterly electronic payments have already begun, and we are in the second of 4 quarters of collecting that 0.5%. Starting in December, in partnership with our third-party administrator, AFLAC, we will then begin opening the process so that employees, sole proprietors, and self-employed individuals will be able to submit applications for benefits so that benefit payments can begin in January of 2022 pursuant to the statute. All right, so who is covered by the paid leave program in terms of those employers that are required to participate? Employers that have 1 or more people working for them, including nonprofits and those in the private sector with unionized workforces, are required to participate in paid leave. That means they must collect the 0.5% from their employees and forward that to the authority to be placed in the trust fund. Those who are sole proprietors or self-employed individuals have the option to participate. And if they do so, they must remain in the plan for a minimum of 3 years. Those employers who are not covered by the paid leave program include those that work for the federal government and some state of Connecticut employees, except those that are covered public employees. And I'll define that in a moment. Municipalities, local or regional boards of education are also exempt unless they too have what are defined as covered public employees. But non-public elementary or secondary schools, so that would normally be our parochial schools and private schools, are not covered by the program by statute. There are other entities that are exempted as a result of other laws other than the paid leave statute. And that would include railroad workers and those who work for other state governments, obviously employees of sovereign nations, those that are engaged in interstate commerce, who may work in the state, but they may live in another one, and therefore don't have any tax obligations to the state of Connecticut. And finally, the category that we do get quite a few questions on are the spouses of active duty military members who have opted to continue to pay their taxes in the state that they consider their home state instead of the state where they may be currently deployed. So those entities and those individuals are exempted from participating in paid leave. A covered public employee that I've referenced earlier is either a non-unionized employee of the state of Connecticut, so all of the managerial staff that is not in a union, or those unionized employees who choose to collectively bargain to be participants in the program. Those who are employed by a municipality, union or non-union, they may decide to participate in the paid leave program through collective bargaining. So here's the way that this would work. If you are an employee of a municipality or a local or regional board of education, and the unionized staff choose to collectively bargain to participate in paid leave, then everyone who works for the municipality and everyone who works for the local or regional board of ed is then included in the paid leave program, whether they are in the union or not. So you are hearing me correctly in that the decision that the bargaining units make with respect to paid leave does drive participation for all employees, regardless of their unionized status in this instance under the statute. Municipality has a very broad definition, as you can see, and it runs from those that we typically understand to be the case as a town, a city, or borough, and runs all the way through a flood commission or an authority that is established by a special act. About sole proprietors or self-employed individuals. If you are a sole proprietor and you pay self-employment taxes as defined by the IRS, then you're not considered an employee and you're not required to participate. But if you receive a W-2, you are considered to be an employee under the law and you must participate. And I know this tends to be disconcerting to some people, I'll use that word. It's true even if you are the owner or the officer of the company and you're the only person there. That is just the way that the law has been drafted. We brought that to the attention of the drafters and we will certainly continue to have that conversation with them. But as it stands now, that is how this process works. So if you're a sole proprietor who also has employees, then your employees must be a part of the paid leave program and you have to collect that 0.5% from them and remit those contributions. A bit more about the contributions. They are managed in this way. An employee contributes that 0.5% of wages, and the employer is responsible for remitting those wages to the paid leave authority. We receive those and we do validate that information against data that we have that's available to us from a number of sources, including the Department of Labor and the Department of Revenue Services. Those contributions are deposited into the paid leave trust fund, and it is from that trust that benefits are paid. Let's talk a bit about what is FMLA versus what is paid FML. We mostly know that FMLA stands for the Family and Medical Leave Act, and there is both a federal and a state corollary of this act. Both of them allow employees to take job protected time from work if they meet certain criteria. But, excuse me, let me just take a sip of water here. Thank you. As Attorney Alexander pointed out earlier, that both the state and federal law, although they offer job protection, those leaves are unpaid. Some employers may require and may offer employees some degree of payment or compensation while they're away. But as it stands today, if someone were to take FMLA under state or federal, that is unpaid unless they could use accrued time to cover the time that they're away. But starting in 2022, that will change in this state. It will change in significant ways. There will be no hours worked requirement in order to be eligible. You will enjoy job protection after working 3 months for an employer rather than 12. There are some expanded reasons for leave, and I can go over those in a moment. There's an expanded definition of family, and then income replacement will be available for those that are eligible under the Connecticut Paid Leave Program. So CTPL is for, the paid leave program that is administered by us as the quasi-public agency, the Paid Leave Authority. All we do is create a source of income replacement benefits for those employees who are eligible but cannot work because of certain family and medical reasons that are outlined in the statute. We do not provide job protection at the Paid Leave Authority. That is up to the employer. And you will also hear it referred to as PFML, or Paid and Family and Medical Leave. The reasons for leave parallel the reasons for income replacement. And they are these: to receive treatment for yourself or a loved one who has a serious health condition. So you would take it for medical leave for yourself and caregiver leave for a family member. You can take it to bond with a child that is new to your family through birth, adoption, or foster care, also known as bonding leave. To care for someone who's been injured during active duty in the military, or to deal with what we call qualifying exigency leave, and that is to attend to specific issues that are associated when a person needs to deploy overseas. That could be childcare codicils, insurance, property, any of those kinds of things. And finally, what is unique to Connecticut is that you may be able to take leave to address specific issues associated with family violence. That leave is available for up to 12 days as opposed to 12 weeks, which is what's available for other types of leave that we have listed here. The military leave is also a bit longer as well. It can be up to 26 weeks of leave, but only 12 of those weeks are paid. So under the Connecticut law, caregiver leave will pay for benefits, and this is starting in 2022, for all of the categories of people who are listed here: a parent, a spouse, a son or a daughter of any age. And this is important because right now the law limits the ability to care for a son or a daughter to the age of 18 or older than that but only if they have a disability. So now when the law changes, care will be able to be provided and time can be applied for to be taken to care for a sibling or grandparents or grandchildren, or what we call an affinity relationship. And that would be people who are related to you, not by blood, but through a relationship that is equivalent to any of the ones that are listed here on the screen. So what is the exact definition of an affinity relationship? It is, in fact, any person with whom the employee has a significant personal bond that's like family, but there isn't necessarily a biological or a legal relationship. Often, and I'll just refer to the third bullet here, we will have folks who will be living together in a significant familial relationship. They may have children together. They may have property that they own together, and they may have been together for some time, but they are not legally married, but they maintain a familial spouse-like relationship. They could, in fact, one of those partners could, in fact, apply to take time to care for the other, should they need to do so under the Family and Medical Leave law when it changes next year, and they would also be able to apply for paid leave benefits as well. So here's a summary of what you would be able to get for FMLA, Connecticut Family and Medical Leave. This is the job protected leave, and then what the benefit requirements are. The federal law hasn't changed at all. You have to work for the employer for at least 12 months, and you have to work at least 1,250 hours for that employer in the 12 months immediately preceding the time that you take the leave. Starting next year, to have job protected leave under the Connecticut Family and Medical Leave Act, you need only be employed for 3 months, and there will be no hours worked requirement, as there exists now under both federal and state FMLA. In order to qualify for paid leave benefits, a person must earn at least $2,325 in the highest earning quarter of the first 4 of the 5 past quarters before the time that they apply for their benefits, and that can be earned from one or more employers. And in addition to that, you can see here, they have to be working and employed in the state, or they were working for the 12 weeks prior to the time they apply for their benefits from the Paid Leave Authority, or if they're a sole proprietor or self-employed individual. They have to be living in the state, and they have to have opted to participate in the program and made contributions as it's true for everyone. The entitlements under leave for each of these types of leave are listed here. Federal, as I mentioned, does not change. You can get 12 weeks in a 12-month period, up to 26 weeks for caregiver leave, for military caregiver leave, but under Connecticut FMLA next year, you can still get the 12 weeks in a 12-month period, because as you may know, right now it is up to 16 weeks in a 24-month period. So that will be changing. The 26 weeks available for caregiver leave still remains available. Only 12 of those weeks, however, will be paid. In addition, as I mentioned earlier, there can be up to 12 days in a calendar year that can be used for family violence leave pursuant to the Family Violence Leave Act. And an employee may be eligible for up to 2 additional weeks of leave if they experience an incapacitation during pregnancy as determined by their healthcare provider. Job protected leave and paid leave benefits parallel one another with respect to the amount of time that can be taken off and the amount of time that can be paid for under the paid leave program. So how are we implementing the paid leave program? We'll talk a bit about the responsibilities as they fall under workers, employers, the authority itself, and the Department of Labor. The workers' responsibilities are to contribute the 0.5% of their FICA wages up to the Social Security contribution limit, which is right now is about $142,800 to the paid leave program. The employer is required, with respect to contributions now, to create an account at the paid leave authority to withhold that 0.5% and to remit it. We at the authority are responsible for receiving and reconciling those contributions, determining whether there's been over or under payments, and imposing penalties for non-compliance. Finally, the Department of Labor, for the contributions, can determine whether or not it will allow any employer additional time to make up for any contributions that they have not made, since contributions should have begun in January of this year, and at least 2/4 of those contributions should have been paid. Responsibilities with respect to claims looks a bit different. So the worker is responsible for submitting their application to both the paid leave authority and their employer at the same time. Workers will be responsible for creating a paid leave account, and that is because that is where all the security lies. In order to check identity, to prevent fraud, they must create an account through which they will submit their own personal information. They will also be required to submit their supporting documentation, update their account with any absence information or any other sources of income that they might have, and they are responsible for notifying their employer about any paid leave claim, and that's by statute. We will be asking employers to complete and submit employment verification because we certainly want to know whether the person is currently working or they have been working for the employer. We will also ask for the validation of absences as well, and we would want to know about any other PTO policies, including whether any other benefits are available, short or long-term disability, because that will affect the amount of money that the person is eligible to receive from the authority. The employer will also, especially this is true for new employers who have 74 or fewer employees, because they would not have been subject to Connecticut or federal family and medical leave. So we want them actually to just refrain from discriminating or retaliating against workers for making paid leave claims, which can happen inadvertently if you don't have an understanding of how family and medical leave works. Now, we are working at the Paid Leave Authority with AFLAC to engage in all of the claims administration. So that we will be working with them to determine their eligibility as a claimant, to collect all the supporting documentation, to determine what the benefit level will be, to investigate any potential fraud, and to impose any penalties based on fraudulent activity. Any grievances or appeals with respect to how either an employer administers FMLA or how we administer paid leave benefits at the authority are all heard by the Department of Labor. A bit more detail about how income replacement benefits will work starting in January. The worker will submit their claim by calling AFLAC or going directly to our site and creating an account and then clicking on the choice that will read Submit Claim. And then they will be redirected to the AFLAC site where they will fill out an application. They will need supporting documentation. There will be a checklist provided to them so that they'll know what to bring with them when they sit down at their laptop or they're on their mobile device and determining to apply for benefits. We'll let them know what they need. But we will be asking through AFLAC all kinds of questions about their reason and the length of leave and the type, and if they have multiple jobs or other sources of income that would impact the amount of benefit they may receive. Now, AFLAC, under our direction and oversight, will be determining eligibility, and they will do so by applying a number of criteria, including all of the statutory criteria I spoke of earlier. Now, if it's determined that a worker is not eligible, AFLAC will notify that worker and they will offer them the opportunity to request a reconsideration. That reconsideration happens automatically before a denial is issued internally. And then there is another level of review that happens at the Paid Leave Authority. But if a claim is approved, which is the default, that claims are approved unless there's a specific reason why they cannot be, then AFLAC will review the supporting documentation. They will notify that worker if anything is missing, but otherwise they will approve the claim. And again, if there is a reason to deny the claim, they will notify that worker and offer them an opportunity to either submit more documentation and request reconsideration. After that occurs, AFLAC will calculate the benefit. We use a number of sources of data, including wage data from the Department of Labor. They will also take into consideration any other types of leaves and that are offsets that may occur. And that will include a reach out to the employer to verify if this person has paid leave, paid time off. If the employer requires the employee, to exhaust whatever other types of leave they have, with the exception of 2 weeks of leave, because that's required under the statute. And then once all of those offsets are determined, then the benefits are paid. They will be issued weekly, 2 weeks in arrears. And so that gives people an opportunity, that gives us an opportunity to make sure that all the benefits calculations are accurate. And we will let everyone know that. Payments will be made either in what we call the stored value card, which is essentially a debit card of sorts, or electronic transfer into an account. There will be no checks issued by AFLAC with respect to these benefits. And finally, a worker has a responsibility to notify AFLAC and notify the authority if there's any changes to their circumstance that would impact their ability to receive benefits. And in fact, when they return to their work, whether if there's a change, if they have additional income, if they have taken another job, or if they are taking intermittent leave, they have to provide frequent updates about their leave usage, and that will generate every time they need to do that. They will need to do that on a specific cadence, and doing that will then allow them to continue to receive the benefit so that intermittent leave can be managed appropriately. Exactly how much will people get? Well, the formula is bifurcated in the statute. If a person is receiving, in terms of wages, less than or equal to the minimum wage, then they simply get 95% of their base weekly earnings. And we know that the minimum wage just went up to $13 an hour. If they are receiving more than the Connecticut minimum wage, then there is this, admittedly rather convoluted formula as to what they receive. But essentially, no one gets more than 60 times the Connecticut minimum wage as compensation. So here are a couple of examples. Worker A receives the minimum wage, and it's now $13 an hour. So the math here is really pretty basic. That person receives their 40 hours a week at $13 and it's $520, 95% of that is $494. Worker B starts with the basis of 40 times their base weekly earnings, right? Which is, in their case, they're earning $13.50, so it's a bit higher. They get $540. They start with 95% of that. It should be $13.50 plus the 60%. So they end up with $506 in benefits per week that they receive. The intersection, and we get many, many questions about this. What is the intersection of employer-provided PTO and other benefits and the Connecticut paid leave benefits? Employers have the right to require, or they can permit a person to use any of the time off they have, their PTO, sick, whatever buckets that they come in, with the caveat that they have to allow a worker to keep up to 2 weeks of whatever that PTO is. So if, for example, you offer paid time off in the buckets of sick leave and personal time, You can require a person to exhaust, let's say, all of their vacation, all of their sick leave time, and all but 2 weeks of their vacation time in order to cover any time that they might be out on FMLA. Now, if you offer a short-term disability policy, obviously how that compensation will work will depend on the terms and conditions of the policy, and we can't tell every employer what that might be. If a worker doesn't receive any employer provider PTO, then they will receive the full amount of their benefit during the leave period. If they receive something that is equal to their full-time leave based on their full-time pay based on their PTO, then they won't receive any paid leave benefits for that amount of leave at all. Let's go to the next one. So here's, look, here we go. Going in the wrong direction. All right, here we go. Now, as I mentioned earlier, this is just a continuation. If the worker receives employer-provided PTO that's equal to their regular pay for a portion of the time that they're out, they can still apply, but those benefits won't start until the worker stops getting their employer-provided PTO. So if, for example, the person is out for 8 weeks, the employer offers 4 weeks of full pay through PTO, and the person still needs 8 weeks of benefits, they will receive 4 from their employer and 4 from the paid leave authority. If they receive less than that, which is the example on the right side, then that worker can receive their benefits when they start leave, but we'll reduce it so that what they receive from their employer and what they receive from the paid leave authority does not exceed more than 100% of the worker's pay. A few more examples. You can tell we get a lot of questions about how this works. Now, an employer, let me see, again, it keeps sending me in the wrong direction. Here we go. So a few tips for workers. If you're trying to figure out what benefits they will receive from paid leave, they should find out from their employer a few things, whether it's a requirement or it's permissible for them to use any employer-provided paid leave, paid time off while they're out on leave. And they should understand whether or not there are any rules about how they can use that time. And in addition, if their employer offers a short-term disability policy, they should know whether or not that policy requires the employee to use any employer PTO or any other state-provided benefits, including paid leave benefits, before they can access the policy, and what impact that will have on the amount of money that they will receive from either the paid leave authority or PTO or any other similar benefit. So there's a bit of work that workers will have to do in order to understand what benefits might be available to them that may impact their ability to get something or anything from the paid leave authority. All right, so just summarizing here what will happen with respect to the claims. So I mentioned this earlier, but with respect to claims, a worker has to tell their employer about the need to take time away in a timely fashion. The statute says at least 30 days for planned time off, and as soon as, I'll just say practicable, if that's not something that can be done. You have to submit your application as quickly as you can and provide your employer with any supporting documentation that you might need. And you do have to comply with that employer's attendance and call-in policies. So here's what we're saying. For Connecticut family and medical leave claims, the employer and the employee do have responsibilities. And that means that the employee has to tell you that they're leaving, and they have to get their family and medical leave approved. And then you as an employer, you do have to establish those policies. You still have an obligation to post a family medical leave poster, what the rights are. You have to have a leave request process in place that follows all of the rules that are applicable to state leave. And you have to manage that worker's return to work. And you do have to refrain from discrimination and retaliation, because sometimes what happens is that a person is out on family and medical leave. You really like the person who's replacing them. And we know that keeping that person who was replacing them in that role and not giving that person their job back when they return is not permissible under family and medical leave laws. That's just an example of some of the ways in which we've seen employers possibly think about inadvertently discriminating, which cannot be done. So at the authority, we don't have any official responsibilities regarding family and medical leave, but we can and we will be continuing to provide training as part of the paid leave program because family and medical leave and paid leave are so inextricably linked to one another. The Department of Labor continues to play a prominent role in how family and medical leave is administered throughout the state. They are promulgating regulations. They will continue to provide guidance to workers and employers about the changes in the family medical leave law come next year. And they are responsible for investigating complaints about family medical leave denials, discrimination, and retaliation. A bit about job protected leave. Again, when the law changes next year, job protected leave will be available after 3 months of employment. But workers should let employers know at least 30 days in advance if the leave is foreseeable. And it's, as I mentioned earlier, as soon as practicable if it's not foreseeable. The employer determines whether or not the employee is eligible for Connecticut family and medical leave, and they ask for the documentation. And then they can turn that person or direct them to the paid leave authority if they require income replacement for the time that they are out on family and medical leave. Once a person has told their employer that they need leave, the employer has 5 business days after they've turned in their paperwork to let them know of their eligibility, to provide them notice of their rights and responsibilities. But it's not the same thing as approving the leave. Let's see. My slides are not participating. Okay, not cooperating. All right, next one. Excuse me. Once a worker has told their employer that they are seeking leave, then the worker is responsible for providing that documentation, and they have 15 days in which to do so. If they're finding it difficult to do so, the employer should give the worker an additional 15 days to come in with whatever it is that they need, their medical certification, adoption documents, whatever the case may be. Then the employer will notify the worker if the leave is approved, and that's after the documentation has been reviewed. They have 5 days once the documentation has been turned in to support the leave request to make a decision and to notify the worker of that decision. And they have to let them know if they are required to use any of their accruals, how they have to report in, and if they need to show that they are fit for duty before they return to work. Worker has to report to the employer when they actually take their leave, and the employer is responsible for making sure that the worker does not exceed that 12-week leave period. And then the employer returns the worker to the job that they had before they went out on leave. If that job does not exist, then they have to return them to a substantially similar job. Same hours, same pay, same rank. There can't be really any significant changes at all. But they do have the right to return to their job with the same terms and conditions. And you can't insist that they be 100% fit for duty or totally recovered. And they have to consider making any possible accommodations under the Americans with Disabilities Act or the Connecticut, Fair Employment Practices Act, which is also known as SAFIPA. Now, there are some complicating factors as you're managing family and medical leave and they include managing worker absences and enforcing your attendance policies and getting timely notice about that. You may receive medical certifications that are incomplete or insufficient. They just don't give you enough information to make an informed decision as to whether or not the person should is eligible to take the leave. There may be workers who are taking intermittent leave, and this has to be managed very carefully against whatever is provided with respect to documentation. Now, there are workers that have fluctuating work weeks. There is the ability to manage interaction between not only Connecticut FMLA, but federal FMLA and other laws. So I will tell you now, and perhaps primarily as employers, that although, as the law currently exists, federal and Connecticut FMLA are pretty easy, relatively speaking, to run concurrently, they will be much more challenging to run concurrently starting next year because job protection is 3 months under state, and it will continue to be a year under federal, and there is no hours worked requirement under the state, and there is still a 1,250 hours work requirement under federal. So there will be some challenges there. And finally, there will be workers who don't want to have their leave designated as FMLA because they don't want to, in quotes, use up their time. but it is the worker's responsibility to designate that time off, and it is the employer, no, it's the employer's responsibility to designate any time off that qualifies as FMLA under that leave, even if the worker does not ask for it. I know that I've covered an enormous amount of information today, and I do appreciate your patience, but on our website, which is ctpaidleave.org, you can find a lot of information in different formats that can give you more about how the paid leave program works. So there is, in fact, an employee rights poster. I remember I mentioned earlier that you should post something in your workplaces or on your intranet or your work websites that's accessible to your employees regarding family and medical leave. But we've already created all of that for you. There is an employee rights poster, and then there's a smaller version of it called the employee rack card that really summarizes it much more succinctly than the poster. And then there's a fact sheet that's essentially in a question and answer format. All of these are available to you on the employer section of the website. For those of you who have not started taking deductions, and there are fortunately very few employers, there's still an employee paycheck mailer that's available that you can include in employee paychecks that will explain what the deduction is for and where the money is going. Everything that I've spoken of is in the employer toolkit, which is a comprehensive guide to how paid family and medical leave will work. And we are here to help you. We do not have a call center, but we do have a contact us feature on our portal. And in there, you can submit questions, and we do try to respond to them within 24 hours. If you require a call back, you can indicate that when you do submit your question, and someone will call you back. In addition to that, we have a number of frequently asked questions and helpful videos that you can use and share with your staff and your HR professionals in order to answer any questions that we may have answered here today, or that may not have been answered in the course of the materials we provided on our website. So thank you very much. And I'll stop sharing for a moment, and we'll go from there.
So Andrea, there are a few questions that were submitted ahead of time that are on the slide deck if you want to.
Yeah, certainly go through those.
Just before we do that, I've been going through the questions as they've been coming through. If there's one thing people remember when they leave today, is that Connecticut paid leave is different from Connecticut FMLA. Connecticut paid leave provides income replacement. Connecticut FMLA provides job protection. So just remember that distinction, that about half the questions that we received relate to that issue. So please remember they're different entitlements. We provide income replacement. Connecticut FMLA provides job protection. They may run concurrently depending upon whether the employee is eligible for both and depending upon whether the employer provides a complete income replacement itself, in which for a period of time, and then our benefits would come in after. But just remember that they're different, and that will help everyone understand the programs better.
And Erin, just following up on that point, because a lot of questions I've gotten are about inconsistent results. In other words, the leave authority will be deciding on eligibility for pay, and the employer will be deciding, maybe based on the same paperwork, about job protection. And what happens if they come out differently on that same subject? In other words, that the paperwork did or did not support a disability from working or a serious health condition meeting the eligibility requirements.
So legally, officially, they're two separate programs with two separate decision makers. So, and there may be reasons for differences, including frequently the eligibility difference. So it may well be the case that an employer denies leave because the employee is not eligible, but we approve paid leave benefits because they are eligible. If there's a difference in terms of we accept medical certification as complete and sufficient and the employer doesn't, there's no statutory obligation for the two decision makers to agree. We will be notifying employers if we approve or if we deny benefits, but there's no sort of ongoing obligation to reconcile.
And I thought that was the case. I just wanted to be sure that everybody on the call understands that.
Yeah.
And when does the employer get notified? I know you said that AFLEC notifies the worker before they move for reconsideration if they're denied. Is the employer notified at that point or only after the final reconsideration request is decided?
I'm trying to read. We have about 30 billion workflows for AFLEC, as you might imagine. So I'm just trying to think back on which one. And there is a point that's earlier. I couldn't tell you exactly when, but there's a point that's earlier on in the process. So after AFLEC has received all of the documentation and made a determination that a person is eligible for benefits, there is a very short note that goes to the employer, usually to HR is where it's going to go, that says this person has applied for leave, for paid leave benefits, they've been approved, they will be out for X number of weeks. And that's about it. Because for a lot of reasons that are really related to confidentiality and HIPAA, that's really all that we can share. And we know that that is the practice in other states as well, that they are informing employers, but they're not giving, enormous amounts of information about the reason for the leave, because it's just, and in many cases, it is assumed the employer knows. Now, we know that there may be instances where an employee may come to us and they may not have told their employer that they're applying for leave. And I can tell you that within the workflow, literally in the script, it says, have you told your employer that you're applying for leave? Because that is a question that will be posed to everyone. It will. So Julianne, it will most likely be by email. It will most likely not be by standard mail. Excuse, that was just something that had come in that seemed appropriate to answer at the time. So employers will be notified, but it will be rather limited because it really is it's a benefit that employees are paying into. But that doesn't mean that we don't understand the really critical role that employers have and the responsibilities that they have. When someone takes leave, someone has to fill that job. They're responsible for managing and tracking their leave so that they're not exceeding the 12 weeks in the 12-month period. So we will continue to have that conversation with employers. They will be notified.
Do you know when they would be notified of a denial?
I do know, but it's not coming to me immediately. Yes, but we will know either way.
Okay,
yeah.
Thank you. I'll let you get to the questions now. Sorry, I just wanted
no,
to
that's okay. And you said something earlier that I wanted to respond to, but it will come back to me. I know it feels incongruent to a lot of people that a person could be eligible for paid leave benefits, but then deemed ineligible by their employer for family and medical leave. So if they apply for family and medical leave and their employer denies that, and they feel aggrieved by that decision, that is the purview of the Department of Labor to make that determination as to whether or not the employer has made an appropriate decision based on the documentation they had at the time that they made their decision. That is one of the reasons that we don't step in, because that is not, we are statutorily not permitted to do that. That is strictly within the purview of the Department of Labor. They are the ones who have the permission and the authority to make that decision. We do not. Okay, so let's go to, everybody's looking at me, that means I must be responsible for doing something. So let me go here to, here we go. All right, so can everyone see my screen?
I
Yes.
think you need to put it into slideshow mode though.
Yep, I'm gonna do that. I just wanted to make sure everyone could see it first. There's no point in going into slideshow if no one can see it. Okay. You can do it. Okay, we don't want it to do that. Let's go again. Just give me a moment to get back to where we were. It's giving me a bit of a fit. Right.
Andrea, while you're doing that, let me just answer one question live. We have a slide that says it is the employer's right to designate leave as FMLA even if the employee doesn't want it. And someone says, "Are you right?" And I said, "I want to tell you, yes, we are right."
Yes, you're right.
Absolutely, the employer's right and responsibility to designate FMLA, designate time off from work as FMLA, even if the employee doesn't want it or says they don't want to. That is your responsibility, and frankly, it protects you and it protects the employee. So if the employee is eligible for FMLA and the reason qualifies, you want to designate it that way.
Because what you don't want to have happen is for an employee to have taken significant time that may have been covered under FMLA. You then take some sort of disciplinary action because of their lack of attendance or a performance issue. And then they say to you, but it should have been covered under. They have inadvertently, I say this a lot, discriminated against that person because you are using the fact that they were out on an FMLA covered absence against them for performance, which is impermissible under the law. That's why you have to do it this way, because it protects you as an employer primarily. So let's go through some of the hypotheticals we've received. Okay, so can your employee take leave to care for her best friend since elementary school who has a serious health condition? This, I think, speaks to the issue of related by affinity. Again, you have to meet the definition of related by affinity if you can prove that that person has the same relationship to you as, let's say in this example, a sibling. So if you have a best friend that you've known since elementary school, but you can't prove that, let's say, for example, they're more like a sister to you, or that you have had a significant amount of contact or communication since that time, you've not spoken to each other since middle school or high school, then that would not necessarily fit the definition of relationship by affinity. But if this person continues to be, and this is just an example, in close connection with you, let's say they're the godparent to your children, or they've taken care of you when you were sick, or they've lived with you for a year while they were getting back on their feet, those are the types of things that you may be able to submit as proof that this person is related to you by affinity as a sibling, and you may be able to apply to take time off to care for them if they have a serious health condition. This is something that will be defined by the Department of Labor. This is not a decision that is made by the Connecticut Paid Leave Authority, and they are now, as we speak, continuing to do their work to define what the proof, in essence, will be that a person will have to submit in order to determine whether someone is related by affinity.
So Andrea, we'll have more guidance on what proof would be required before this goes into effect.
Yes, you will. And that's DOL's purview, and they are working on that. And I want to say that we are in close partnership and relationship with DOL, but we're also very clear what we can do statutorily and what is their responsibility and what authority they have. And we don't want to overstep our bounds. So that is in DOL's purview. So the second scenario is that the authority grants leave to one of your employees, but again, you don't believe we just answered this one. The medical information supports the employee's absence from work under the reason for having a serious health condition. Can you deny the leave even though the authority has granted the benefits? I think Erin just answered this question. The answer is yes, you can deny the leave. However, if a person meets the statutory requirements for leave under the paid leave statute, then we may very well approve them for paid leave, but they will not have any job protection, and they may not have a job if in fact they've worked for less than 3 months, or you've denied them leave and now they have an unauthorized absence from work because you've denied their leave. And that is something that the person may file an appeal about with the Department of Labor. Next question here is that an employee starts a 4-week leave in December 2021 and for her own serious health condition, then it extends into January of next year. Can they qualify for the benefit even though their leave started actually prior to 2021? And the answer is yes, they can qualify for paid leave benefits even if their leave began in 2021. So starting in 2022, they would be eligible for the remaining 8 weeks of leave, the remaining leave that they have in 2022. So if they've already taken, Erin, I think this is right. If they've already taken the 4, then I think they have the 8 remaining, or do we start again with the 12?
So I was just actually responding to somebody in the chat about this. Connecticut has said essentially this switchover period, you can look back over the applicable 12-month period to see if the employee has used any leave. And so if they've used any leave in the prior 12 months starting. So if they come to you in January or February of 2022, you can look back over the past 12 months to see if they used any Connecticut FMLA leave. And if they did, you can subtract that from their 2022 entitlement. I will Actually, just so everyone has it, I'll put the CTDOL policy into the chat. And that's the best way of making sure everybody has it.
Thank you.
Thank you. Erin, I love when you catch the softball. It's so great. So thank you for that.
I'm just so happy they actually wrote it up for us.
Exactly. Okay. So the next question that was posed to us is, if you're a Connecticut employer and you have folks that are working remotely in Massachusetts, New Jersey, and New York, are they entitled to benefits under the Paid Leave Act, even though they don't physically work? That's my insertion there in Connecticut. So the answer is this: although they are working remotely in these other states, if you consider them Connecticut employees, meaning that you have an unemployment insurance and payroll tax obligation for those employees in this state, we use that as very strong guidance to suggest that that person remains a Connecticut employee, and they are in fact required to participate in the program by submitting the 0.5% contribution. And they are also then entitled to benefits, even if they're not physically working in the state, but maybe they were prior to the pandemic. Now, if these are people who, even though you're a Connecticut employer, but they work in Massachusetts, New Jersey, New York, and you don't have really any employment obligations for them to the state of Connecticut, then they are not entitled to benefits, nor are they obligated to participate in the paid leave program by making a contribution. But remember, for workers, where they live is not relevant to their obligation to participate. It's really where they work and where you as the employer have an unemployment insurance or payroll tax obligation with respect to that worker. All right, we actually get this question quite a bit. So if a workers' compensation claim is denied and then the employee applies for paid leave and that's paid, what happens if the claim is later overturned, and how is that overpayment sorted out? We have a number of workflows for overpayment. And so I'll just speak to a couple of them. If the person has a workers' compensation claim and that's denied and they apply for leave, at that moment, they are not barred from receiving any paid leave benefits, because the bar only arises if a person is receiving workers' compensation or unemployment compensation at the same time as they apply for paid leave. You can't get both. But if they're not receiving anything at the time, then there's no bar. If they later get their workers' compensation overturned and they do start to receive benefits, then those Connecticut paid leave benefits not only stop, but any overpayment that they would have received, if it's applied retroactively, is then deducted from any paid leave benefit that they would have received or may continue to receive if they ever receive payment again. There is also a mechanism that will be in place to collect overpayment from anyone for really any reason. So that's essentially how the workers' compensation claim process will work. And it will be very similar for the unemployment insurance process as well. So if a person applies for UI, they don't get it, they come to paid leave within their 12-week period after immediately preceding the time that they lose their job, then they eventually end up being approved for UI, then the paid leave benefits stop. We then determine whether or not there was any overpayment, and we do pursue that overpayment from the claimant. Next question: if we use a TPA to manage leave, even if an employee receives their approval, can we require them to go to the TPA for your job protection? Well, if you're using your TPA to manage all of your absences, then certainly that practice does not have to end because now there is a job protection component that triggers sooner than it would have under the current law. So if you're continuing to use your TPA for job protection now to determine whether someone has that after having worked for a year, then there's no reason to stop that process now. You can continue to have them do that, knowing that you as the employer are still ultimately responsible for the decision that TPA makes regarding job protection. Any tax implications that you should be aware of? I'm not sure about the full implication of this question, but I can tell you from the employee standpoint, the statute permits an employee to make a decision as to whether or not they can receive their benefits with or without taxes being withheld. If they choose to receive it without the taxes being withheld, we will do so and issue them a 1099, and then they are responsible for whatever tax implications arise from receiving the benefit with no taxes withheld. If they choose to have taxes withheld, state and federal, then we will do that as well, and issue that person the appropriate paperwork that they will need in order to be able to file their income taxes with their provider or their preparer. All right, question about how quickly applications and benefits will be reviewed and approved. Erin, I don't know if you wanted to take this one. I'm happy to, but maybe you just want to answer this one quickly.
Sure. So applicants are supposed to provide us with notice 30 days in advance for foreseeable and as soon as practicable for non-foreseeable. The eligibility determination will be done promptly, and we will ask for any supporting documentation that they have not yet provided. Once we get a complete certification, the decision for approval of benefits will be made within 5 days of that complete file, 5 business days. And then if it's approved, we'll pay, basically we pay, as Andrea said, every Tuesday in arrears. So if someone is approved for January 2nd to January 8th, their benefit payment will be issued to them on January 18th.
Our next question is whether employers should wait to pay an employee under their short-term disability program until they hear how much the employee will receive from the paid leave authority. Well, this is a question that, even though it is simply and succinctly asked, is not as easy to answer, because it really does depend on the terms and conditions of each short-term disability policy. What we know will happen is that when an employee applies for their benefits, we will be asking the employee themselves, whether they are eligible for any other benefit from their employer. We will also be asking the employer the same thing. So in some cases, it might be appropriate to wait until the employee has exhausted their benefit from their employer, and in others, we may pay right away. So it all depends. I really can't give you a specific answer about this, but there will be an opportunity to coordinate benefits as the determination for the amount of benefit will be paid. So that decision can be made on a case-by-case basis.
And I think if your short-term disability policy requires that it kick in only after all other paid benefits are paid, and depending on the deadlines that are in your policy, that is something that you may want to consider doing. But I agree with Andrea, it depends what your policy says. But that is a possibility, to not pay until you know how much they're getting from the paid leave authority under some circumstances.
Absolutely, because we do want to avoid a circumstance where the person is receiving more than 100% of their weekly pay. So in those instances, it may make sense to wait, but again, it depends on the policy. The next question we have is, how many weeks in advance should an employee apply for benefits? Well, the statute says that they should apply, they should let their employer know at least 30 days before they intend to take leave, if that leave is foreseeable, meaning they're going to have surgery, or they have a C-section scheduled, any of those types of things. We're really not asking people to apply for benefits any sooner than 6 weeks prior to the time. And that is because circumstances in a person's health or the circumstance of the people that they're caring for can change fairly quickly. So if you know that you're going to be out in April, we truly ask that you not apply in January. It's fine to apply in March, or maybe even the latter part of February if you know you're going to be out in April. But we really ask that you not apply more than 4 to 6 weeks before the time that you're looking to receive your benefit, because then it just delays the process of if information changes throughout that time period that may affect the calculation or eligibility. When we educate employees about receiving benefits and tax withholding, what we will do, we will not be offering tax advice. We will let employees know that they have the right to receive the benefit with or without the tax withholding, and that they should confer with a tax advisor in order to understand the implications of taking the benefit with or without the withholding. So we will be letting them know that that right exists, but we will not be offering any tax advice as to the pros or cons of taking it one way or the other. Those are all the questions that we received. We really want to thank Littler for allowing us the opportunity today to speak to hundreds of you about the paid leave program and where we are, and to answer the questions that you have. Let me turn my video back on. So there we go. So
Andrea,
we really do appreciate the opportunity. I'm sorry, go ahead.
I'm sorry, I know we're over time, but we got a couple of questions for people who are like, if we just discovered that we're supposed to be paying into CT paid leave, what do we do?
Oh my,
I just want
okay,
to answer
well,
that.
sure.
Register, go right away.
Yeah.
As soon as you leave this meeting, go to ctpaidleave.org and follow the instructions for registering. The obligation to remit contributions began in January, so you do have a debt that you're going to have to pay. There is for another 34 days a catch-up period that the Department of Labor has authorized, where employers can actually take up to 1.5% of employees' wages to help kind of catch up for the debt that for those contributions that they had not been withholding before that. So get on that real fast. If you weren't taking contributions from your employees and that catch-up period, which goes through the end of September, doesn't satisfy you, you as the employer may be on the hook. So you'll have to cover your employees' contributions and deal with the tax consequences associated with that. But if you haven't done it yet, you better. If you have a third-party administrator like an ADP, they most likely they've registered for you and have been remitting for you. We still need you to register for yourself because we need information that ADP wouldn't have, like who you want us to contact for claims questions. So hopefully your payroll provider has covered your contributions, but you still need to register.
And Erin, my understanding is that the authority so far has not imposed penalties in order to encourage employers to go ahead and sign up. Is that still the case?
That is still the case. We understand this. We know this word is very overused. These are unprecedented times, and that employers are managing all kinds of challenges. And we are not looking to become another one of those challenges by imposing penalties, because we also know there are a number of employers, like some of them we encountered today, that had absolutely no idea that they had this obligation and that they wanted it and that they need to adhere to it. So we really want to give employers the time to do that. And then if we feel that enough time has elapsed and we still have employers that haven't complied, then we will then determine what those penalties will be. We will propose those, they will be approved by our board, and then we will impose them on employers that are non-compliant.
Great, well, thank you. So I do want to thank both Erin and Andrea very much for taking the time. This was very informative, I think, for everyone. And from the audience, thank you for participating today. I know there are a lot more questions. We may want to do this again as we get closer to January 1st, but we're happy to guide you through this. And I know the Leave Authority with the website where there are questions and answers, you're available to clarify things as we move forward. So thank you everybody for your participation, and I hope you all have a wonderful day.
Thank you. Thank you very much.